Hi, I'm Paul Young, a partner in the firm of Young, Marr, Mallis Associates. Welcome to the Paul Squared podcast. I've been helping clients file for bankruptcy relief and Social Security claims since 1986. I created this podcast to provide an overview of the bankruptcy and Social Security disability process and hopefully answer the most frequently asked questions. My goal is to help clients regain financial stability and support them through the challenging times of either being unable to work or pay their bills due to a disability. While this podcast serves to provide some general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the various laws within those areas. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have any questions, please feel free to contact me at 215 639 5297 or visit our website at www.youngmarlaw.com. That's youngmarrlaw.com. That's youngmarlaw.com. Thank you.
All right, everyone. Welcome back to Paul Squared, Legal Insights into Criminal, Bankruptcy, and Disability Law, brought to you by Paul Young and Paul Mallis, where we're going to discuss some of the intricacies of Chapter 13 bankruptcy. So, Paul, welcome back.
Thank you, Pete. Glad to be here.
So, Paul, in prior episodes, you introduced yourself, and then we started getting into the generalities of bankruptcy overall, some of the decision-making that goes into somebody deciding whether bankruptcy is the right solution for them or not. And then we focused some attention on Chapter 7 bankruptcies, and you discussed some of the differences between Chapter 7 bankruptcies, Chapter 13 bankruptcies. So in this episode, we're going to focus our attention on Chapter 13 bankruptcies. And one of the questions I think you and I, after sort of going over what we discussed in Chapter 7's episodes, realized we maybe had missed a question that is a common one that you get from people, and that is, how much debt do they need to have before they should be considering bankruptcy in general? Could you start us off by answering that question?
Sure, Pete. I would say there's no set amount. It really is based upon the circumstances that someone faces and their household income and their so on. So for some people, $5,000 or $10,000 might seem overwhelming and it might be appropriate to consider bankruptcy. There's other people that they would say, well, if I could up 30,000 or 40,000 or 50,000. So I don't think there's a set amount. I think it's something where it's when it becomes too much for you to handle.
Gotcha. So again, it's one of those things where someone's situation, depending on all the totality of all the things they have going on in their life, is an analysis that needs to happen to determine whether it makes sense for them to file or not.
Exactly.
Okay, great. Appreciate that. So as we're talking about Chapter 13 bankruptcies, I think a good starting point here is we need to explain again what a Chapter 13 is.
Sure.
One of the things that sort of popped in my head, why is it called 13 versus the other being 7 or not?
That's a very good question, Pete. There really is no good answer, except it's part of the bankruptcy code that's under Section 13. Other than that, I wish I could give you a very insightful answer. There is none that I'm aware of.
It has nothing to do with it being the unlucky bankruptcy or anything else.
Exactly.
It's just the code, the title of the code.
13 could be called the Chapter 72. It wouldn't have mattered. It just happened to be 13 because that's the code section that it is covered by.
That's the actual chapter.
Yes, it's actually Chapter 13. But what I would say the general concept of a 13 is that there's a repayment plan for one reason or the other. That's what a Chapter 13 has become synonymous with. There's either a 3 or 5 year repayment plan, and that's the foundation of the bankruptcy.
And I think you had mentioned in previous episodes that one of the distinguishing factors of a Chapter 13 is that it has some element of a secured credit or secured debt as part of the debt that's being potentially dealt with in the bankruptcy proceeding. Is that correct?
In most cases, you
Okay.
could be there's distinct reasons people are filing a Chapter 13. One would be because of what you described, paying back secured debt, whether it's arrearages or whether it's a full loan. Like, for example, sometimes people pay a whole car loan through a Chapter 13 plan because they need to, because maybe the car was repossessed. But there's also an element of people who file Chapter 13, remember, because they didn't necessarily qualify for a Chapter 7, and they
Okay.
still are predominantly being aided with their unsecured debt. So that would be because either A, they had too much income to qualify for a Chapter 7, B, they had too much equity and assets to qualify for a Chapter 7, or C, they actually filed a prior Chapter 7 within 8 years. So
Okay.
those people are forced to file a Chapter 13 if they're going to get relief. And oftentimes they're just paying back a small percentage of their unsecured debt, maybe not even dealing at all with any type of mortgage arrears or car issues or taxes.
So secured or unsecured debt could be a part of 13, but really the distinguishing factor is you're in a payment plan. It's not a complete
Correct.
discharge like you would have in 7 of certain kind of debts.
Correct. And there's certain people that a 7 won't, even if they were eligible, wouldn't bring relief, and that would be what we described, the person's behind maybe on their mortgage or their car payment.
And when you've talked about previously that the bankruptcy system, the process is designed to be debtor friendly. I'm assuming then that when they look at a payment plan for somebody, it has to be something that calculated, through math, something that's calculated that that person will be able to make those payments on a monthly basis.
Well, you hope so. I
Yeah.
mean, the one distinguishing factor in a Chapter 7 versus a 13, let's say, is not every 13 is successful, unfortunately. And you start by letting the client know that, hey, it may not work because we're limited as practitioners in a 13. I have to present a plan where someone can pay back their mortgage arrears. And if they can't, then unfortunately, if financially it's not feasible, it may only bring a temporary setup. It might give them a chance to get back on their feet and decide what's next. Maybe
Right.
it's in some, you hope in every case it's repaying the arrears, but in some cases it may turn out to be, it gives them time to kind of restart and say, hey, you know what, this isn't going to work. We're gonna sell our home. We're going to do some other things. So not every 13 is successful, unlike a Chapter 7, where almost every 7 reaches a discharge. A 13, only a percentage do.
And so it could be the situation where someone just has too much debt that even in a repayment plan, they can't pay it back. And that's potentially a different analysis for them where, maybe they're going to see that this is, like you said, it's just going to provide some temporary relief to get your house in order to figure out what's the right path forward. Or I think you had mentioned before, someone could lose their job after they enter a plan and they don't have the income to even make the
E-
minimum payments.
Exactly. There are people, that's why Chapter 13s, if they get dismissed because someone can't make the payments, you're not precluded from refiling until you've usually reached a certain point. So if someone is dismissed because maybe, as you were saying, they lost a job and they can't make the payments, 6 months later, if they're in a better financial position to make it work, they can refile and they're not precluded. It
Okay.
usually takes 3 or 4 filings if someone was unsuccessful that many times for a court to say, we're going to limit you from refiling.
And I'm assuming there's a somewhat general premise under all this that the courts want to see creditors get paid back as much as they can. They want to see people be able to keep their house and make payments on it. And so they're trying to find the paths forward to do that when it's feasible.
Yeah, I mean, I think what you're saying, Pete, and you're right, is there's a balance. The court and the trustees are looking at a situation where, and the Chapter 13 trustee is the one that oversees this process. They have an obligation to assist both in protecting the debtor, but also protecting the creditors. So in theory, if a Chapter 13 is successful, it helped everyone. It
Right.
helped Creditors get paid, especially secured ones who had to get paid. It gave a path to the debtor to see their way out and to get back on their feet. So it helps everyone, both creditors and debtors.
And how often when you're dealing with someone who files a Chapter 13 is a home involved, a house, an owned house involved?
I would say probably at least three-quarters of the Chapter 13, maybe more, of the Chapter 13 bankruptcies involve mortgage arrears. It's where someone owns a home and they fall behind for various reasons. That's the majority. There's certainly a percentage, again, that are filing a 13 because they didn't necessarily, they have unsecured debt, but their income might have been too high to qualify for a Chapter 7, and they're paying back just a small percentage or percentage of their unsecured debt.
But the majority of the Chapter 13s you
Are
see have some home
Yes,
ownership involved with it.
yes, that's the majority.
Okay. And in those scenarios where there's a house involved, we often hear the term foreclosure put out there. What can you explain what a foreclosure is and
Sure.
what's the process of a foreclosure?
Absolutely. When someone's reaches a certain point, they've fallen behind a certain number of months, the mortgage company has decided that it's necessary to take steps to start the process to take the house back to lead to a sheriff's sale. That's what a foreclosure is. It's basically a claim that the person is a certain number of months behind and that they want to move forward with repossession or retaking of the property. That's what a foreclosure action is. And it's a precursor to a sheriff's sale.
And so in a foreclosure action, so when someone takes a mortgage out on a house, they're signing a contract saying, bank, you're loaning me X amount of money and I'm going to pay it back to you in monthly installments over a certain period of time. And that's the contract. And so when someone's unable to do that, the bank's recourse is to say, we can try to force a sale on this house to recoup the money that we're owed. And that's the starting point to that is the foreclosure process. So is step number one that in order for this to happen, that a bank has to file a lawsuit against an individual to start foreclosure proceedings?
Yes, yes. In other words, to start to take the property back, the foreclosure action is the first step. Thereafter, obviously, there's a number. Bankruptcy is one of the remedies to prevent a homeowner from losing the house and having an orderly way of repaying. Because by then, unfortunately, most homeowners aren't in a position to just write a check for whatever they're behind. So
Right.
that's what that gives them the ability to do, is to repay it over time in a bankruptcy. And
So
that's what
say someone's behind on their mortgage payments. Do you have a sense for how long? I mean, do they're behind 1 month and suddenly they're a defendant in a lawsuit?
No, what happens is there is actually a process in Pennsylvania. They get first a notice of intent to foreclose, which is usually maybe 3 months behind, which is basically saying, hey, we're going to take steps.
Okay.
Then they get something called an Act 91 notice, which is telling them, okay, now we're starting the foreclosure process in 30 days. So usually by the time someone's getting a foreclosure complaint, it's going to be a minimum of 5 or 6 months behind on their payments. It could be more because a mortgage company could have been taking a little bit longer to start the process. It varies, but it's going to be a little bit of time, at least 6 months before you're usually going to get a foreclosure complaint. And then by the time the next step would be if a homeowner didn't do anything further, a foreclosure judgment would be entered, and then it would be set up for a sheriff's sale. But usually by then, we're talking about another 6 months. So you could be talking about a year from the time the homeowner made their last payment. And anytime you file a bankruptcy, there's something called an automatic stay, which automatically prevents any further action on the mortgage company's part from occurring.
So anywhere in this process, a bankruptcy filing basically stops anything further from
Yes,
happening until the bankruptcy is worked through.
Exactly. We come into play from anywhere from somebody's a couple months behind to the day of a sheriff's sale.
Okay.
So we can stop it.
And in this process, so you say there's some letters that come to the homeowner that say, "Hey, you're behind. We intend to file foreclosure proceedings," to this 91 letter to the complaint is actually filed. And when a mortgage company is looking to file a lawsuit against the homeowner to force a sale of the house, it's filed in the county that the house exists in, correct?
Yes,
Okay.
correct. That's correct.
In your experience, are people not going to have had plenty of chances to know that this process is going on?
Now they do. They know because before it would actually go to a sheriff's sale, not only would they receive the foreclosure notice, the foreclosure complaint, there's also has to be a posting. So they would also get something posted on their property. So they know. But unfortunately, either one of a few things happen oftentimes. One, I think they're paralyzed by what's occurring.
Yeah,
And oftentimes they believe, okay, I'm somehow going to be able to remedy this, whether it's I'm going to come up with the money, whether it's I'm directly, excuse me, I'm going to be able to possibly work something out with the mortgage company, either in the form of what's known as a loan modification, where I could restructure my loan such that I can become current again,
yeah,
or it's just inertia,
yeah,
fear. So yeah, they do have notice. They unfortunately sometimes it's just not knowing where to turn.
right.
Or we talked about job loss. Sometimes it's maybe at that moment they lost their job and they're not in a position to do anything. And maybe they're hoping, okay, in the interim, I'm going to get another job. I'm going to be working again. I'll be able to afford payments more. So there's a lot of factors.
Well, and if somebody's in arrears, they haven't made payments. Let's just say that they owe $10,000. They're behind $10,000 at that point. If the mortgage company has already started foreclosure proceedings, even if they pay the $10,000, does that automatically mean that they're now caught up and they're back to normal, or can the mortgage company continue to proceed along the foreclosure route even with getting the back payments?
The answer is they could continue to proceed. Most times, if somebody could become fully current with the reinstatement amount, which would include also their costs, if they started foreclosure, their attorney's fees, the arrearages, usually it's going to stop the action. But unfortunately, most people aren't necessarily in a position to become fully current at once. And I can tell you what does happen oftentimes is I'll get calls from people who say, I was out of work, I'm behind, they started foreclosure. Now I'm working and they won't take my payment.
Right.
That's the more common occurrence that they won't take monthly payments at that point. And that's where unfortunately for the homeowner, or fortunately, a bankruptcy is an option because at that point it's forcing the mortgage company to accept the monthly payments again, along with making these additional payments to a trustee towards the amount that they're behind.
Right, and I would assume that once a default's happened on a mortgage, a payment's been missed or whatever, the 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 bank can proceed upon what route they want to go unless they're forced by bankruptcy. And I understand your point that they want to get paid, and if they feel like they can get caught up and they don't have a problem moving forward, they'll probably take the path of least resistance. But that doesn't mean they have to do that.
No, you're correct. The only thing that I tell people, the only way you can guarantee that a mortgage company is going to comply, and because some people are concerned, they've been told my mortgage company said they won't accept any payments. When they're in a bankruptcy, they have to accept
Right, right.
your payment. They have to allow you to resume making your monthly payments, which is a big relief to homeowners.
Yeah, it's not their choice anymore.
Right.
The mortgage
Exactly.
companies.
Exactly.
Yeah. And so if we sort of walk along this timeline again, so someone misses payments, they get these letters from the mortgage company telling them they intend to file foreclosure. A foreclosure lawsuit is filed in the county where the property resides. The judge will take on the case, and if the homeowner doesn't make an appearance or show up at court to defend this in any way or answer to any of this, what it will happen at the court level at that point if they don't ever show up?
Well, in most cases, they don't, because really, in most cases, they're not really disputing that
Right,
there's been payments made. So most homeowners aren't going to spend the costs involved with defending a foreclosure where they really don't have a valid defense.
right.
So what would happen is the judgment would be entered. And once a judgment is entered in that case, that's when they can proceed forward with listing the property for a sheriff's sale. And
Okay.
but that takes usually some time to get it from that point to, it's probably 3 or 4 months till it would get, at least 3 or 4 months until would get listed. But again, any bankruptcy filing along the way would stop it.
Right, and but the typical stages you would see are that, they either don't show up at court, like you said, they have to admit they're not making payments, so they're in breach of their mortgage contract at that point. So they either get a default judgment or a judgment, and with that judgment, the mortgage company now has the ammunition they need to force a sale of the home, which in the mechanism I think you've described is called a sheriff's sale, correct?
Yes, correct. That would be the next step in the process. If an agreement again wasn't reached with the mortgage company anywhere along the process to do to modify the loan and to start reaccepting payments under new terms.
So why do they call it a sheriff's sale?
Because it's actually, years ago in particular, pre-pandemic, it was always done through the local sheriff. So the sheriff is actually conducting the process. It's still in most counties or some counties in Pennsylvania done by the sheriff. In others, it's done an online process. So it's still overseen by the sheriff. So that's actually, so they're literally the people that are putting the property up for sale.
So if it's a property that's been foreclosed upon, a judgment's been entered, the bank has now taken this judgment and hands it to the sheriff and says, "I want to sell this property to get my money back." What's the process of a sale with the sheriff? Are they listing it with realtors? What happens at that point?
What happens is it's actually an open bidding process. So it's set in each county for certain dates of the month. For example, in Philadelphia, it's the first Tuesday of the month. In Bucks County, it's the second Friday of the month. And what happens is at the time of the sale, if there's nothing to stop it, the sheriff's sale, either somebody's going to bid on it, in which case the highest bid would take the property, or if there's nobody bids because there's not enough equity to cover the amount that would be necessary for the mortgage company, then what happens is the property goes back to the mortgage company and they now own the property.
So it's an auction.
It's an auction. Yes.
Okay. So it goes through a sheriff's sale, and let's say that somebody bids $50,000 on the house, and there's a $40,000 mortgage. $40,000 paying off the mortgage. That person now owns that house, even if it's worth $100,000.
Yes, exactly. And if it's above the mortgage amount, the difference goes back to the homeowner after the sheriff's costs.
But I would assume that most of the time, the people who are bidding at these sheriff sales are looking for good deals, and you're not selling it at market value, and your chances of
Yes.
you getting your full equity back in your house is limited.
That's one of the purposes, even though it's not really the sole really the sole purpose, but sometimes it becomes the purpose in someone filing a bankruptcy, is they're listing their property for sale. They plan on selling their property, but they're in a situation where they just don't have the time yet.
Yeah.
And they need the time to try to sell it rather than be in a situation where they let it go to sale at a sheriff's sale. For what you were saying, they're going to not get fair value for the property.
Yeah, and
Even
in a
if they're gonna
sheriff's
sell it.
sale, it sounds like that the homeowner has no control over who it's sold to. The sheriff doesn't care. They're going to say,
Not
"Hey, you're bidding enough above the minimum level. It's yours."
exactly. And usually it's going to be for less than value.
Yeah. So I think you described this, but anywhere in that process that we just went through, from a judgment being filed, a judgment being entered, the mortgage lender taking the judgment and forcing a sheriff's sale, that process can be stopped if a bankruptcy is filed.
Yes, that's called the automatic stay, and that's a provision in the bankruptcy code that automatically puts a halt to any action brought by any creditor, but particularly in this setting, a mortgage company.
Okay. And is it a similar process if someone owes back taxes on a property or
Yes,
owns other things?
back taxes are very similar. That's also done by a sheriff. That's also brought to a sheriff's sale. That's a very similar process. Again, now those are the two primary um, functions of the 13 in stopping a sale of the real estate. There's judgment creditors. For example, a credit card company could get a judgment, and they could be planning to try to auction your car, and or garnish your bank account. And bankruptcy also serves to stay that type of action.
And in any of those scenarios, or maybe even worse, perhaps in a tax sale where the amount owed is even less, you lose control over your ability to get market value for your house. All that equity you've built up can just evaporate because that it's being sold to pay off this minimal amount of debt.
Absolutely. The one exception, not the but the one in Pennsylvania. There's actually, I believe, other counties outside of Pennsylvania, but in Pennsylvania, Philadelphia, you have a right, what's called redemption, where if the property is sold at a tax sale, if you decide you're able to pay off the taxes, or you file bankruptcy to pay off the taxes, and the sheriff's costs within a 9-month period, you can still save your home. So a purchaser at a sheriff's sale for taxes in Philadelphia has to wait till they do it to do anything for a 9-month period, because you have a right to it's called a right of redemption to get the
But that's a
property back.
very specific and
A very
geographically
narrow,
unique.
yes,
Okay.
yes.
So if someone's house is scheduled for sheriff's sale, we're here on a Saturday talking about this, but if it was scheduled for sale on a Tuesday or Wednesday of next week, is there still a possibility that that sheriff's sale can be stopped?
Yes, we could, one of the tools we have is the filing can immediately. So, for example, as we're speaking now on a Saturday, there happens to be tax sales coming up. Excuse me, sheriff sales coming up relating to mortgage foreclosures for this Friday. We could file at any point prior to Friday, and it will automatically stop that action.
Gotcha. And I think you mentioned this, but the equity that someone has in their house, even if they have more equity than is what is owed on a mortgage, does that in and of itself stop a sheriff's sale, or how does that play into all this, or does it at all?
It's not an easy question to answer, but I'll try to make it as concise. It plays into it from a standpoint of, once you file the bankruptcy code will allow you a certain amount of equity, where they look at it as if, okay, if you were going to liquidate your home, we'll let you keep a certain amount of equity. Anything beyond that would have been available to what we described before as unsecured creditors. So therefore, we're going to allow you to keep that portion of equity, but anything beyond that, we want you to pay back that amount of unsecured debt in your plan. So when you're filing a Chapter 13 plan, not only is a person paying back mortgage arrears, but if they have equity above a certain amount and they have unsecured debt, they would have to pay back a certain amount of that unsecured debt. If they don't have unsecured debt, it wouldn't matter for the plan purposes. And if they don't have above a certain amount of equity, that unsecured debt, again, credit related debt, would be gotten rid of potentially in the bankruptcy.
And that's if someone files for bankruptcy and as part of their plan, they're considering selling this property and pulling some of the equity out.
Well, no, it wouldn't even be that they're actually selling it. It would be the court's going to evaluate if they were to sell it. Do they
Okay.
have equity above a certain amount? And if they do, then you have to pay back that. They do it what's called a liquidation analysis. They
Okay.
look at it and say, okay, we're not going to force you to sell your property. But if you were, and you can keep your first X number of dollars, would there be funds available to pay other unsecured creditors? If the answer is yes, then those creditors have to be paid back. If the answer is no, then they wouldn't, based
So
on
it's
the
all part of the
liquidation.
calculation of
Yes,
figuring out how to administer a bankruptcy if it's been
Pl-
filed.
exactly.
Okay.
Exactly. It all comes into play when you're coming up with what would be a feasible Chapter 13 plan.
But absent a filing of a bankruptcy, the amount of equity you have in your house is kind of irrelevant if it goes to sheriff's sale. If someone buys it above your
You're
mortgage
right.
amount, you're going to get that back, but it doesn't mean you're going to get market value
No,
for it at all.
exactly. And that's why sometimes I've had people call me and say, I'm planning to sell my property. What happens if I just let it go to a sheriff's sale instead? The problem would be if the bid is extremely low,
Right.
you might not be getting near. So yes, the amount of equity that you really have in real dollars doesn't come into play if it's
And
sold.
if someone's house has gone through sheriff's sale, do they have any options at that point?
That's in Philadelphia, that's where they can still redeem it if it's a
Is that for
tax sale.
sheriff's sale?
No,
Just
that's
if
a
it's a
sheriff's
tax
sale if
sale?
it's a
Okay.
tax sale.
Yeah.
If it's a mortgage foreclosure, their options are very limited. You can file a motion to set aside a sheriff's sale, but there has to be grounds, and the grounds are very limited. The grounds are really procedural. Maybe they didn't serve the person properly. Maybe there has to be some error of law to set it aside, and it's very limited.
Excuse me. So
Sure.
if someone's considering, that bankruptcy might be something that is going to work for them, that is going to help protect their home and protect the equity they build into it, there really is no reason to be waiting until you get closer to share. You're putting yourself more at risk that something's going to happen. It sounds like if they're behind on mortgage payments and they can't come up with the money to make it whole again, the earlier in the process they examine their bankruptcy options, probably makes a lot more sense for them to do it at that point.
Absolutely. The only exception to when it really doesn't make sense to do it is either if they're in a circumstance where they really have a reasonable chance of catching up, which is unusual, or the second is if their circumstances are going to change such that they're going to be in a much better position to make a plan work 2 or 3 months later than they are right this second. And that would usually be like a job situation. Someone's income is going to appreciably be higher 2 or 3 months from now. And as long as they're not facing a sheriff's sale yet, they might want to wait to file till they're in a better chance to make it work.
And so someone's in this situation that we described. Are there any alternatives to filing Chapter 13 if they can't come up with the arrearages and get the mortgage company to take them?
Very limited. I mean, the only alternative is the only two alternatives really are to one, sell their home,
Okay.
or two, if they somehow could work out an agreement with the mortgage company, like a mortgage modification where the mortgage company redoes the loan, puts all the arrears in the loan, and re-amortizes it so that they can start over again. Short of those outcomes, a bankruptcy really is the only thing that's going to make any sense for purposes of stopping the sale and then giving you a chance to try to repay it. But if you can't, even then to regroup.
Right. And so a loan modification that you just mentioned, that's basically the mortgage company saying, look, this loan that we're currently under isn't working. You can't pay it. We want to get paid. We'll consider re-establishing our contract in a way that looks like it's a feasible plan moving forward. is there anything forcing the mortgage company to do a loan modification?
No, there isn't, and it's a very frustrating process for people, only because of what you've described. People, I think, are under sometimes led to believe that it's going to be accepted when it isn't, and now with what's happened as well with interest rates having gone up over the last, obviously, whatever it's been year, the modifications that are being offered, so the new terms are based upon the higher interest rates. So
Right.
someone might have a loan of that was originally 3%. They're being told, Great, we'll re-amortize, we'll offer you this modification, but we're going to put all the arrears in there and redo the whole loan based on 7%.
Right.
So now their payment has gone up significantly. Now they're not facing a foreclosure at that point or a sheriff's sale if they accept it, but it becomes, instead of having to be paid back in a bankruptcy $30 or $40,000 over 60 months, they're now paying a loan that's $300 or $400 higher for 30 years
Right.
potentially, and
So
it turns out to be much less advantageous if they can't,
So
for
it
long
may
term.
give temporary relief in terms of a monthly payment, but you're going to be paying more over a longer period. So if someone has $100,000 that they owe and they're behind, and they talk of a loan modification, and they were paying $750 a month, maybe they get it down to 500, but their term might have gone from I have 10 more years I owe on my mortgage to
Exactly.
30.
That's exactly right.
Okay.
And so I would say to you, that's more of a recent development, especially with higher interest rates. Years ago, that wasn't occurring. When these loans were modified, they were modified at the same rate that the person had. So it usually was advantageous if they were offered a modification. I have people for the first time since, because it's really been, rates have been low for quite a while, rejecting modifications and saying, no, I'd rather pay this off in a bankruptcy over a 5-year plan, even
Right.
though it's going to cause a strain. In the long run, I'm going to be better off.
Right. Just because of what you would pay in interest over a much longer period
Yes.
of time.
Yes.
Okay. Can someone file for Chapter 13 bankruptcy if the house in foreclosure is not their primary residence?
Yes. Yes. It
Okay.
would serve the same purpose. It doesn't need to necessarily be a primary residence. It could be, the other thing is, it could be, there's other reasons that they could file to relating to a property. For example, again, I had an older woman contact me with her son, who, it's a reverse mortgage, where they haven't been paying the taxes. So the mortgage company pays the taxes and the homeowners insurance, and now they're facing a foreclosure
Mm,
based on that.
okay.
So there are some other, I mean, there are some other home related, and so it doesn't have to be your primary residence. But in most cases, I would say it is. But there are cases where people had maybe an inherited home or a summer home that they want to try to save. And that, remember, Chapter 13 bankruptcy isn't exclusively relating to a home.
Right.
A lot of times it really is relating to a car as
Right.
well.
Okay. And can someone make too much money to file for a Chapter 13?
No,
Okay.
they
That's
can't. Now
never
they
an
can
issue.
that's never an issue. They can make too much money to file for a Chapter 7. A
Okay.
Chapter 13, if they're making over a certain amount, it just means that they're going to necessarily have to pay back potentially unsecured creditors, and might be a situation where you get up to 60 months to pay things back in a bankruptcy. If you're making over a certain amount, the trustees although it's pretty rare, is at the liberty of shortening the plan to claim that you have more disposable income. So we want it paid back in a shorter period of time, even though you're provided up to 60 months.
Gotcha. And is the same thing true? Can they have savings and retirement accounts and still file a Chapter 13, or how does the court look at that?
Absolutely. It's again this liquidation test. So you get exemptions for a certain amount of assets, be it equity in a home or other assets. Because of that, what would happen is the court would look at it as if we liquidated your total estate, your all your assets, your home, and we said you're entitled to a certain amount, but anything beyond that, you have to pay to unsecured debt. And that's so what it does is in a Chapter 13 setting, if people have unsecured debt like credit cards, instead of being able to get rid of them because of these assets, they may have to pay them back in the Chapter 13 plan. The Chapter 7, again, in the corollary is in a 7, you can't have these assets. If you do, you could lose them.
Right. Right.
They could liquidate it and take them.
And if is there upfront cost for people to file a Chapter 13 bankruptcy? What does something like this typically cost for
Yes.
them to?
Sure. A Chapter 13 bankruptcy, we have the flexibility. Just to give a comparison again to a 7, a Chapter 13, we have the flexibility of putting money in a plan. So that plan that they're paying back to the trustee, we can put part of our fee in it. So generally, a Chapter 13 bankruptcy is anywhere, depending on the circumstances and the complexity, of $1,000 to $1,500 in upfront payments, plus the court costs, which are $313, and then the balance of our fee we can accept over this 60-month plan, which is usually approximately $3,500 or so in the plan. So total fee of a Chapter 13 is anywhere from $4,500 to $5,500. A Chapter 7 is anywhere from $2,000 to $2,500 plus the filing fee of $338. But the difference is in a Chapter 7, there's no plan. So unfortunately, the
You have to be paid
trustee
upfront.
it has to be paid up front. If not, it's considered a preference. You can't pay us after the date you file.
Right. But it sounds like in the Chapter 13, after that initial filing fee and the upfront charge to you, that the remainder of the fees can be paid over time as part of
Yes.
acceptable monthly payment that
Yes.
the person can presumably afford.
And it makes it really is more manageable for people when they're in a situation they have to pay back anyway. Our portion of the payment that they're making is very minimal. It's usually $50 or $60 a month.
Gotcha. So if someone's considering filing a Chapter 13 bankruptcy, what are the basic steps? What do you tell them they're going to be looking at having to do in order to get this actually filed?
Okay. Usually, again, the most important is what we're doing now, is sitting and assessing what their situation is, because really you can see there's a multitude of reasons people are filing a 13. Could be that they're strictly mortgage arrears. Could be that they have mortgage arrears and they have a lot of equity in their home and they have unsecured debt. So the most important part is clearly the assessment part. Then after that, it's documents. We need to get pay stubs and tax returns and bank statements. But I don't think we try to make that process not overly burdensome. It's a little more burdensome when someone's self-employed, because then they have to produce ongoing profit and loss statements for the trustee. And also, a large part of this whole process depends on where they're at and what they're facing. So, for example, if they're calling me and they say my car is ready to be repossessed, we have to do it in more of an exigent, emergent, circumstances, and we don't have necessarily as much time to gather documents. If they know they have a sheriff's sale, but they know it's scheduled 3 or 4 months out, we can give them a little more time to come up with things, and even financially, they don't have to make the payment as quickly because they have some time.
It's always better to be not up against the gun on doing these things so you can get all your
Absolutely.
information. But if you're in an emergent situation, you still have
Yes.
options.
Pete, it's one of the necessities, or I should say one of the realities that we face doing bankruptcy work, that unfortunately, yeah, it would be much better if people thought about these things in advance and assessed but I think to a large degree, again, they're numb and they've been beaten down. And a lot of times the reality is I'm meeting or talking to someone as the circumstance as it's developing. They have a
Right.
sale tomorrow.
Right.
They're outside and their car's ready to be taken. So I don't necessarily have it. It's a business where we have to learn to be reactive.
Yeah.
I'd like to be proactive all the time, but a lot of times it's reactive.
Sure. And I guess a couple final questions here as we wrap
Sure.
things up. Someone who goes through a Chapter 13, can you just briefly describe, similar to what we did in discussing Chapter 7s, what's this do to someone's credit history, their ability to get loans in the future, and things like that?
Sure. Same kind of thing we described in Chapter 7. They did the mortgage payments that they're going to be making, the car payments they're going to be making, they're going to reestablish credit. The one thing that's a little bit different with the Chapter 13 is it's going to take a little longer to get a discharge because the process takes longer because they're in bankruptcy longer. So it's going to take a little bit more time for purposes of getting, of being in a position where they can reestablish credit.
But it'll be available to them if they
A-
stick to their
Absolutely.
plan. And yeah,
Yes, it'll become accessible. It's just to they have to have a little bit of patience with that.
great. Well, Paul, I think that was a great overview of the Chapter 13 process, the options for people, what happens when someone's facing foreclosure and sheriff sales and things like that. Again, I know in an ideal world, you'd encourage people to visit and talk to you earlier in the process so that they understand and can have full options, but that's not always a possibility. And that
Right.
as long as the sheriff sale hasn't happened, there's still options as it relates to the house and things like that. And regardless, to talk to you if they're facing the situation.
Absolutely.
So I want to thank you for sharing your insights on this episode. And our next episode, we're going to be starting into Social Security disability insurance and discussing some of the details and intricacies that go into that. And we hope people tune into that and learn a little bit more on the Paul Squared podcast.
Okay. Thank you, Pete.
Thank you.